Hello friends, be ready for legal passage. 3, 2, 1, start. Heard Learned Counsel for the petitioners. Learned Standing Counsel for the respondent numbers 1 and 2 and the Learned Counsel for the respondent number 3 Gaon Sabha stop para. The petitioners contend that very same plot was subject matter of controversy in a proceeding under section 33/39 of the UP Land Revenue Act on a previous occasion when the same of the petitioners were directed to be expunged by the order of the subdivisional officer dated 17/8/2006. Stop. The petitioners challenged the same in revision number 238 of 2007 and the said revision was followed by the learned additional commissioner on 12/9/2007. Stop. A certified copy of the said judgment has been filed as Annexure 3 to the writ petition. Stop. Para. Shri Tiwari, learned counsel for the petitioners, submits that again the same action has been taken against the petitioners without adverting to the said order and in violation of principle of natural justice by relying upon a mere report of Tehsildar. Stop. Learned counsel submits that the sub-divisional officer has travelled beyond his authority by ignoring the order of the additional commissioner and secondly by proceeding to pass an order without giving notice or opportunity to the petitioner. Stop. Para. It is settled principle of law that a long-standing entry cannot be reversed in summary proceedings under section 33/39 unless a patent error can be established. A question of title cannot be investigated in view of the bar contained in section 40A of the 1901 Act. Stop. Para. In the instant case, it is clear that entry was sought to be corrected on the basis of the revenue record of 1347. Firstly, stop. This was reversed by the learned additional commissioner on the previous occasion, which a direction to proceed on the basis of Khatani that was existing on the eve of the abolition of Jamindari, that is 1359. Firstly, the Khatani of 1359 firstly does not appear to have been reviewed. Stop. Thus, there was no occasion to have proceeded ex parte against the petitioner to have passed the impugned order. Stop. Para. Apart from this, an administrative authority has to be rest its decision after following the principles of natural justice and recording reasons. Stop. The impugned order now where indicates that notices were issued to the petitioner prior to expunging of their names in the present proceedings. The order of the subdivisional officer, therefore, can be straightway set aside as it is in violation of principles of natural justice in view of the law laid down in the case of Whirlpool Corporation versus Registrar of the Trademarks 1998 8 SCC 1. Stop. Para. It is also to be remembered by administrative authorities that the reasons for the order cannot be supplemented by an affidavit, and therefore it is not necessary for this court to grant any time to the standing counsel to file a counter affidavit. Stop. The order has to be supported by the material recited therein as held by the apex court in the case of Commissioner of Police Bombay versus Govardhan Das Bhanji AIR 1952 SC 16 para 9, the ratio whereof is extracted here under colon para. An attempt was made by referring to the commissioner's affidavit to show that this was really an order of cancellation made by him and that the order was his order and not that of government. Stop. We are clear that public orders publicly made in exercise of a statutory authority cannot be constructed in the light of explanations subsequently given by the officer making the order of what he meant or of what was in his mind or what he intended to do. Stop. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed and must be constructed objectively with reference to the language used in the order itself. Stop. Para. Thus, to provide any opportunity to the standing counsel to file a counter affidavit would be a futile exercise when the impugned order ignores the order of the additional commissioner dated 12/9/2007, which could have been brought to the notice of the officer had any opportunity been given to the petitioners. Stop. Para. In view of the submissions so raised, it is apparent that the impugned order does not notice the order of additional commissioner dated 12/9/2007. Secondly, the impugned order on the face of it is in violation of principles of natural justice. Stop. The subdivisional officer therefore appears to have travelled beyond the authority and in violation of principles of natural justice while passing the impugned order. Stop. Para. Consequently, the writ petition deserves to be and is hereby allowed. Stop. The order dated 4/9/2013 is quest. Stop. It shall be open to the sub-divisional officer to pass a fresh order in the light of the observations made herein above. Stop. सो फ्रेंड्स, आपको ये डिक्टेशन कैसी लगी कमेंट बॉक्स में ज़रूर बताइएगा। प्लीज़ मेरे वीडियो को लाइक करिएगा, शेयर करिएगा और सब्सक्राइब तो कर ही लीजिएगा। तो मिलते हैं अपने नेक्स्ट वीडियो के साथ। टिल देन टेक केयर एंड बाय बाय।